The Father Ted creator, Graham Linehan's Heathrow arrest is a stress test of three things at once: the legal boundaries between offensive speech and criminal incitement, operational policing priorities, and the government's duty to align the statute book with public expectations. It exposes contradictions that neither culture war partisans nor ministers can ignore. Graham Linehan was detained at Heathrow by 5 armed officers on Monday, and he was questioned about 3 April posts on Twitter on X, then released on bail with a condition not to use Twitter pending a further interview. The Met described the arrest as on suspicion of inciting violence related to Twitter posts, and was confirmed that he was taken to hospital as a precaution before being bailed. Linehan says one post advised calling police on trans-identified males in women's spaces, and if all else failed, to punch them in the balls. 2 other posts were a disparaging caption on a protest photo and a reply saying, "I hate them." He denies wrongdoing. Wes Streeting has said police should focus on policing streets rather than policing tweets, and that ministers will look again at whether Parliament has layered too much speech policing duties into forces, or onto forces. And Sir Mark Rowley has added that officers shouldn't be policing toxic culture wars and asked for clearer law. Conservatives have called the arrest absurd, while Green leader the new Green leader, congratulations, Jack Polanski, has described it as proportionate. J.K. Rowling has called it totalitarian. Expect the case to surface in US hearings as an example in the UK free speech debate, and Farage apparently promises that he's going to bring it up with Trump. There are 2 overlapping families of offences: the incitement to violence or hatred under the Public Order Act 1986. Section 29B targets words intended to stir up hatred on grounds of sexual orientation, maximum 7 years in prison. The CPS guidance is explicit that sexual orientation in this regime means same, opposite, or both sexes. It doesn't include transgender identity, which sits outside that specific 29B framework. And the general public order or communications offences that capture threats, menaces, or encouraging violence, and police sometimes reach for Public Order Act provisions or the Communications Act when posts cross from insult into threats and exhortations to assault. The Met's wording points to suspicion of inciting violence rather than a charge as yet, and where the prosecutors can fairly shoehorn these facts into an existing offence is the crux. This raises a narrow but important question. If officers cited 29B in arrest paperwork, critics will argue a category error, since 29B covers sexual orientation, not transgender identity. If instead they point to a different offence focusing on encouraging violence, the analysis shifts from identity-based hatred to a straightforward exhortation to assault. The legal footing matters. So 3 tests are central about where the line is likely to be drawn. The first is intent. For 29B, the Crown must prove an intent to stir up hatred. For other incitement or threats-based offences, the question is whether the words encourage violence against a class or person. Punch him in the balls looks like a call to commit assault, but courts also consider context, irony, and the ordinary reader test. Streeting is right that context is king, and maybe this should have been called out at the time of Lucy Connolly's arrest. Secondly, specificity and imminence. Criminal law is more comfortable when a post targets a person at a place and time, and a generic provocation about a class is harder but not impossible to prosecute if the language is plainly an exhortation. And thirdly, the protected categories and drafting gaps. Parliament has strong specific provisions for race, religion and sexual orientation. Transgender status is protected in equality and hate crime aggravation frameworks, but not identically mirrored in the 29B stirring up offence. That asymmetry creates confusion on the ground. There's an issue here about proportionality and operational judgment. Sending 5 armed officers to an arrivals gate for a speech offence looks to many like a mismatch of means and ends, and Rowley argues his officers are in an impossible position, tasked to enforce a sprawling and sometimes vague statute book while being judged against burglary, clear-up rate, street crime priorities. Ministers cannot wash their hands here. If Parliament wants fewer speech-based arrests, Parliament must rationalise the law. Bail conditions that bar a suspect from an entire platform are blunt instruments. They can be justified where there's credible risk of further offending or harassment, but they must be necessary and proportionate. If Linehan challenges his ex-ban as an unlawful prior restraint on political speech, the court will weigh Article 10 rights against risks of repetition. That is fact-sensitive, but the breadth of platform-wide ban, that will attract scrutiny. What this means for Parliament, the episode exposes 4 problems that can be set out quite clearly. 1. The UK has accumulated speech offences piecemeal. Vague thresholds like grossly offensive invite uneven policing. A consolidation and clarifying exercise is overdue. Shami Chakrabarti and the former DPP Sir Max Hill have called for exactly that. The stirring up provisions treat sexual orientation differently from transgender identity, and Parliament should decide either to extend 29B style clarity to gender identity or to narrow the field, but ambiguity like this helps no one. The CPS should publish refreshed guidance on when exhortations framed as jokes cross into prosecutable incitement, and that would give frontline officers a clearer gatekeeping test and reduce headline-grabbing arrests that later collapse. And ministers say they want officers on the streets, then they must rewrite duties and metrics accordingly and stop outsourcing cultural disputes to constables at the gate of Terminal 5. 2 things can be true at the same time. First, telling people to assault others in women's spaces is ugly and irresponsible. Second, arresting a returning passenger with an armed team for 3 posts risks looking theatrical and invites accusations of viewpoint policing. The principled way through is not to pick a tribe, but to fix the drafting, publish tighter guidance and demand proportionality and enforcement. That protects trans people from harassment and women from threats, while also protecting political speech, satire and fierce criticism. So what should we be watching out for next? If prosecutors proceed with which exact offence will they rely on, and how will they how will that progress in terms of intent and so on? Secondly, any judicial comment on the X-ban will matter beyond this case, and so one should be careful. The bail condition could be challenged, and it's and Linehan may get into trouble for what he says or what other people say. And then there's a government review. Streeting and Rowley have both put the ball in Parliament's court. Watch out for Home Office moves to rationalise speech offences this autumn. Watch out also for whether or not this comes up in the PMQs in a few minutes. In a mature democracy, the answer to noxious speech is usually better speech and targeted action against real threats. And when the law is clear and the policing proportionate, both liberty and safety win. At present, neither is well served, as is demonstrated clearly by this case and by the Lucy Connolly case.